So the state is asking the court to do a final order. Uh, Mr. Strong is not present, so just speak to confirm arrears of what is. Or actually, we don't even have to confirm the arrears. If we can go ahead and address the current support. Really, my understanding is Mr. Strong was ordered to provide documentation. He's not done that. Ms. Thomas will testify that Mr. Strong was well, I don't know if the Army has a CDL, but he was a truck driver in the Army, that he has the skills and training to drive truck, that he was previously working for FedEx, but he had to step down, at least according to him, because of the medication that he was taking, but that he's still a licensed truck driver. And so my request to the court would be to use uh, Bureau of Labor Statistics data for the Killeen Temple Metroplex. I realize the court doesn't love using that data, so I would ask the court, instead of using the median wage, to use just the 25th percentile wage, and instead of 40 hours, I'd ask the court to set based on 30 hours in an abundance of caution. So if the court does that, the lower 25th percentile hourly wage, $20.36. The court probably already has the math in his head, but at 30 hours, it'd be $610.80 a week, or monthly of $2,646.80. And then Ms. Thomas will also testify that Mr. Strong had two children when this case started. He now has three, and that youngest child lives with him. So um, guideline child support going forward, 1 in, 3 out, $339. And then Ms. Thomas has TRICARE because of her service, and Mr. Strong served as well.
All right, and so I'll ask if you get some information from Ms. Thomas, make sure that she know whether or not he's getting any type of VA at this time, please.
Yes, Your Honor.
All right, thank you. All right, at this time, Ms. Thomas, I'm going to go ahead and ask you to unmute yourself and raise your right hand. And all right, ma'am, do you solemnly swear or affirm your testimony you're going to give here today is the truth, the whole truth, and nothing but the truth, so help you?
Yes.
All right, then. And Mr. Diamond, was there a CSO doing an investigation on whether or not the father has a VA at this time?
Your Honor, due to the time constraints, I don't know that the CSO was able to take a look into this.
Okay. All right, then. Well, I'm a little. It sounds like this gentleman may be getting VA on. But let's maybe mom knows. So let's see. Okay. All
Yes,
right,
Your Honor.
we'll take it from there.
Thank you, Your Honor. I'll call Ms. Thomas.
All right, thank you.
Ms. Thomas, will you state your full name, please?
Samantha Marie Thomas.
So let's talk about Mr. Strong. Do you know if he's receiving any sort of a disability?
No, I don't.
Do you know what the circumstances of his separation from the Army? Well, first of all, Mr. Strong was in the military at some point.
Yes, he was.
Do you know what the circumstances of his separation were?
No, when he did get out, he just told me he was getting out. He didn't go into detail why he was.
Okay. What do you think the likelihood is that he'd be receiving some sort of disability?
Honestly, I don't know. I don't know of anything. I didn't know he had high blood pressure until he told me back in March. So there could be a possibility, but I'm not sure.
Okay. Did Mr. Strong tell you what he did when he was active duty?
He was an 88 Mike, which is a truck driver.
Okay. And is he, do you know if he's still capable of driving a truck?
The last thing I know, the last thing I was told was that he had a job, but they let him, or I guess they gave him time off because the medication that he's taking, they deem unsafe for him to drive.
Okay. And what was the company he was working with?
FedEx.
Okay. And when did he, it sounds like they backdoor fired him. When did they backdoor fire him, for lack of a nicer term?
I don't know that.
Okay. All right. So the numbers I'm requesting the court to use, and I think I've told you this already. You certainly don't have to agree to that with them, but I'm requesting the court to do a final order based off of federal wage data. Do you have an objection to me doing that?
No, I don't.
Okay, and Your Honor, I would offer what's been marked as States 1. I can share my screen if.
Go right ahead, please. And Mr. Diamond, did you do I may ask you to go ahead and tell me what the amount would be if I ordered the full 40 hours a week, okay?
Yes, Your Honor.
All right, thank you.
So, Your Honor, States 1, it's a printout from the Bureau Labor Statistics. I apologize that this is so fine. And I can, so anyway, so I'm sorry. So I offer States 1.
All right, ma'am, this shows what the average person, this is different categories, but this is, and this is a total sheet that shows a lot of different areas, but it shows what the average is for someone working in different professions in the state of Texas and in the, I think it's the Temple, Killeen, Belton area. So is there any legal reason this should not come in evidence before the court, ma'am?
No.
All right, States 1's admitted, Mr. Diamond, and you may proceed.
Thank you, Your Honor. And may I scroll down, Your Honor?
Yes, you may.
And so would call the court's attention to, and forgive me for not highlighting, Your Honor, heavy and tractor trailer trucks. And this number here, $20.36, is going to be the 25th percentile hourly wage.
All right, duly noted. And I know the state had some figures for that at 30%, at 30 hours a week. And I'll let you tell the court what those are again on the record, sir.
Your Honor, so if the court uses 30 hours, it'd be $610.80 a week, which would be $2,646.80 monthly. If the court were to use 40, and again, I know the court can probably do this math in his head, I cannot. So it'd be $814.40 weekly, monthly average of $3,529.07.
And the current child, okay.
I'm sorry, Your Honor. And if the court wanted, I can have another 26 seconds. I can give the court the guideline calc on that. So based off the 40 hours, Your Honor, I calculate guideline child support at $443.31 and would request the court to round down to $443.
Right. All right. Anything else, Mr. Diamond?
Your Honor, Miss Atha just messaged me. She's in the process of checking to see if there's VA disability. I can, if the court wanted to recess this, I can hopefully have an answer for the court in the next 5 minutes.
All right, thank you. That'll be helpful because again, I'm looking at using the 40 hours a week because we gave the father the opportunity to come back in here and set the record straight, and he's not doing it. So I'll give him the benefit of the doubt as far as I can, but you know, this was his to do, and I'm not going to take it. I'm going to do what I consider to be in the child's best interest. So I'm probably going to go ahead and look at least that amount you requested at the working a full 40 hours a week, sir. Thank you.
Thank you,
But
Your
right
Honor.
now, ma'am, I want to give the investigator the opportunity to see whether or not they can find whether or not he's getting VA disability, and obviously that will affect everything we do here. All right, but we'll reset for a few minutes here and let her, and hopefully we'll have that data in the next 15 minutes. Okay, thank you.
Okay.
So not a whole lot of agreements. I believe there's agreement that the state's requesting non-disclosure. I believe Mr. Manning is not opposed to that. But I believe that's it as far as agreements. State is requesting to confirm arrears as of 12/31/24, and I believe the pay record will show $2,467.80 on the child support and $3,814.03 on the medical support. The court probably noticed that the child support started after the medical support. That's why the difference. But the state is requesting 63 repayment on the child support and 70 on the medical. And then the calculation on the guideline child support, I'm sorry, I believe that the evidence will be that neither party has access to healthcare at reasonable cost. So requesting $184 on the cash medical reimbursement, And that's based, I'm sorry, and I'm getting ahead of myself. Gross of $4,081.65. $2,791.65 of that is VA benefits. $1,290 of that is income. And then guideline child support, I have 949. And I'm sorry, there's 2 in, none out. And then the step down I have is 759.
Give me that amount again, please. 900 and what?
949 is the guideline amount that I calculate, Your Honor. And then 759 would be the step down.
All right. Anything else, sir?
That's what I have, Your Honor.
All right, folks, I'm gonna go ahead and swear both of you in. I'll go ahead and get what you're requesting the court to do based on these circumstances. And again, I didn't give my long speech this morning because I was under the impression that we were doing something a little different today, and I was going to be limited to what was in the 4 corners of the documentation as far as the child support review order. But this is a motion to modify. And the bottom line is, in this matter, the math's the math. And if somebody asking me to deviate from what the guideline support is, that the legislature says I'm supposed to order in every case these circumstances are as such, and the amounts are the same. Like I said, if this was done in 100 different courts today in the state of Texas, 99 of them would have this exact same amount as the final order. So if you're going to ask me to, anyone's asking me to do something different, you're going to have to give me a legal reason why it should be done and prove the circumstances of that reason. So I know you're not lawyers, but that's the best I can do for you. That's what I can tell you what you need to do. And so at this point, I'll go ahead and swear you both in and let the state ask y'all questions, and we'll see where we can go. So at this time, I'll ask both Mr. and Ms. Manning, both of you to raise your right hands, please. You both solemnly swear or affirm your testimony going to give here today is the truth, the whole truth, and nothing but the truth will help you.
I do.
I do.
All right, you're both officially under oath. You can put your hands down, and we'll go ahead and take it from there at this time. So, like I said, at the end of the hearing, if either of you have anything that you think I need to know that didn't come out during the testimony that was elicited by the state, then you'll be allowed to give the court that data. But this time, I'll go ahead and let the state call you as individual witnesses, and we'll take it from there.
Thank you, Your Honor. Call Ms. Manning. Ms. Manning, will you state your full name, please?
Heather Jane Manning.
All right. Were you able to hear the opening I gave the court just a couple minutes ago?
Yes.
And do you have any objections to the numbers that I requested of the court?
No.
Okay. Do you have health care available to your children through your work or through another source at a reasonable cost?
They get state Medicaid, and one gets Medicaid and one's on Social Security disability.
Okay. All right. And then do you have any objection to the state's request for non-disclosure?
No.
Okay. And maybe you can answer this with just a yes or no. Do you have safety concerns with your address being published?
Yes.
Okay. I'll pass a witness, Your Honor.
All right, I won't come back to those safety concern circumstances, but I'll need a little bit more on that based on whether or not this is something that's happened since the last order before the court. Was the last order have the prior order have a non-disclosure?
Yeah, I'm sorry I should have brought that up in my opening. I read the last order, Your Honor, and it wasn't entirely clear to me. Neither party's address was published in the order, but I didn't see specific findings that non-disclosure was appropriate. It was a CPS order, and my guess is they probably felt like they had bigger fish to fry.
Right. Okay. Good enough then.
And I guess I'm sorry, Your Honor, if I could maybe say one more thing. I believe the safety concerns are because of the CPS involvement. I don't know if there's going to be anything new to add. And I was hoping not to dredge all that up in this hearing. I think the parties are not. I don't think either party objects to the non-disclosure.
Oh, okay. Thank you. All right, then I'll let you go ahead and call your next witness, please. Thank you.
Thank you, Your Honor. Call Mr. Manning. Mr. Manning, will you state your full name, please?
McKinley Wayne Manning.
And I forgot to bring this up as well in my opening. You are a veteran, sir?
Yes, sir.
Okay. Let's talk about that. Do you have insurance available to you through TRICARE or another source that would be affordable?
No, sir, just the VA.
Okay. And let's talk about the VA. I believe I I show $2,791.65 is your current VA benefits. Is that correct?
Yes, sir.
Okay. And what are you doing for work right now?
I manage a CBD store,
Okay. And what are you making an hour doing that?
$12 an hour,
And how many hours in the average week do they give you?
25 if I don't if I don't have an appointment.
Yes, sir. Um, and I told the court just a minute ago, you're not opposed to Miss Manning's address being published. Did I tell the court correctly?
That's correct.
Okay. All right. And you heard the numbers that I gave the court. 949 is what I calculate for the child support and 184 for the medical. I take it you're not in agreement with those numbers?
I mean, even the step down. At the end of the day, I know I have no choice in paying that. The only questions I had was, I don't know if this is what I come into now or
Yeah.
after
This is
the
your opportunity to tell the court why that's unreasonable. So why is that unreasonable?
The only thing is for the VA maybe retroactively taking my pay back and reducing me to $150 a month for the time that I was incarcerated. And also, I received a notice from the VA that Ms. Manning put in an apportionment request for $1,200 a month for the two children. So if this ends up coming out, I will not be able to pay that.
All right, his bill served, and the apportionment is granted by the VA, then that counts against any amount that we order you to pay. All right. I can't tell the VA what to do, believe me. I've tried for years as a lawyer and a judge, but yeah. But bottom line is anything that's taken out of them based on an apportionment for child support counts against your child support that is owed, sir. Okay.
Okay, thank you.
All right, no problem.
And
That's just the rule.
can
Okay. Yes,
I have
sir.
a question on that there?
I'll let you go ahead and proceed, sir. Thank you.
If that is approved, how do I go about notifying child support on that case?
Well, I'm
So
gonna
that
order, if
way,
it is approved, I'm gonna order both of y'all. You have seven, well, I'll make it 7 day. I'll make it, y'all both have 5 business days upon receipt of that information to get that information to the state, and that's gonna be in your court order. All right.
okay, thank you, sir.
All right. You may proceed with your questions, Mr. Manning, at this time. Thank you.
The only other thought that I had on that, disregarding this, is that if on the other end of the VA spectrum, if they retroactive my pay down to $150 a month, I really have no way of.
Sir, I understand that, but there's nothing that is a speculation at this point. If they do it, I hate to tell you this, but the way you deal with that, and again, you still owe the money because what they're saying is you were paid when you weren't allowed to be paid. So I know what that means. But the bottom line is you still owe the money, and you would have to come back in and based on that actually happening, give the court that data, tell me how long it's going to last, that sort of thing. And maybe at that point I can come up with a new order that's more appropriate, but I can't base an order going forward on something that may or may not happen, sir. Until it actually happens, I can't rule on it.
Absolutely. My biggest thing, like I told Mr. Diamond, is just the fact I just, run the risk of, I don't want to, be incarcerated for non-payment child support and or have my license suspended because of that. And I was just trying to figure out the means of coming and bringing it to the court.
Or you can bring that information, like I said, to the AG, but they take a while. So unless you can figure out how to way to do that paperwork yourself, you may have to talk to a lawyer. You may have to talk to a veterans a program through legal aid or something like that. I'm not sure where you're coming in from, sir. But again, it's imperative that you get that you both get that information to the state. But actually, to get it before the court will require someone to file something, and the state may take months to do something like that. And believe me, it's problematic. So the burden will be up on you, sir, to get that to the court by some means, either by pro se, in other words, your own paperwork and proper paperwork, or getting a lawyer to do it for you, sir.
Yes, sir. Gotcha.
All right. Anything else you want to tell the court at this point, sir?
Off the top of my head, no, sir. Those are my two biggest things.
All right, then. Well, again, I'm looking at going ahead. I got the math's the math. I got to look at ordering that. I got to look at reducing the judgment, the unpaid child support and cash medical in order the monthly repayment is requested by the state. That covers the interest plus some tear down of the principal that is owed. And of course, I'll look at waiving court costs. So at this time, I'll ask both of you in just a moment about right now, sir. You're the witness. Is there anything based on what you just heard? Is there anything else you think the court needs to know about your current circumstances?
About my current circumstance, I mean, no, sir, other than the possible fact of losing the pay and the possible apportionment,
Well, again, sir, when those things
I
happen,
believe.
that's
Yeah,
when I need to be informed. All right.
absolutely, sir.
All right. All right, Mr. Diamond, any other questions of this witness?
No, sir. And state rests.
All right, then. All right, at this time, Ms. Manning, is there anything else you think, anything else you're asking the court to do here, or anything else you think I need to know, ma'am?
No, not it. Actually, yeah, I do have a question. The child support, the arrears, is if he continues to non-pay, is that something that I have to file to come back in front of the court again, or is that something that you guys will ask his employer to withhold from him, or how does that work?
Ma'am, I just rule, and I can't give you legal advice because that's what you asked me right there. All right. The bottom line is, we don't. You can ask the state how they're going to try to go ahead and get the monies from them. Obviously, there'll be a wage withholding order, but I will let you know we cannot send. No court can send a wage withholding order to the VA. We can to DFAS, but not to the VA. They don't accept them. But hopefully, if you get the apportionment, they'll take care of that. It sounds like the amount that you're requesting the enforcement will cover both the child support and the repay on the judgment. But until then, that is his responsibility, and it's part of the court order. And of course, the court would, if you want to file your own motion for enforcement, you can. The state can file their own motion for enforcement. It's left up to you all. It's left up to you and possibly your counsel how you want to handle that. Would want to handle that going forward. But again, man, like I'm telling him, I can't speculate. I can only, when something happens, then once I know the circumstances, then I can make a informed ruling on what I need to do.
Okay, that's fine.
All right. Okay. Any other questions, ma'am?
No, sir.
All right. Mr. Manning, any other questions, sir?
No, sir.
All right. Then again, Mr. Diamond, obviously I'm granting the modification. I'm going to go ahead and grant the step down, obviously when the first oldest child emancipated, reducing the judgment, the unpaid child support, cash medical, auto repayment is requested. I want to waive court costs due to military service, but I am on my own motion adding that information that if, based on the testimony we have, if either party gets information concerning that the apportionment by the Veterans Administration has been granted, then they have 5 business days to get that information to the Attorney General's office. If they've got your email or however y'all get that stuff set up, they can. But again, folks, that just because you do it in 5 business days don't mean it'll be up before me anytime in the next 6 months unless somebody gets me unless somebody files something personally. All right. So
Yes, sir.
but I've ordered it, and I'm sorry, and the well, and of course I'm granting understanding granting non-disclosure by agreement. Anything else at this time, Mr. Diamond?
No, that's it, Your Honor.
All right, folks. Thank you folks very much. Good luck to you. And again, sir, if that happens, you need to get it. You need to get that. And there's an old thing called song called "Beat the Drum Slowly." Don't do that. Beat the drum fast and get it. And if that happens, you need to get that in there one way or the other, fast as you can, by yourself or by your counsel or through the state. But the court needs to get that data as soon as possible. All right. Thank you
Yes,
both
sir.
very
Thank you.
much. And we're off the record, and everybody try to stay warm this next week. Okay. Thank you.
Thank you, sir.
Thank you, Your Honor. And if I could have you both back in the breakout rooms, I've got the order prepared. I just need to add judge's language, but I'll have you the order in 5 minutes.
Okay.
Thank you both.
Mhm.